Hello, my name is John P.L.C. I'm a probate litigation attorney in Florida, in West Palm Beach, Florida, at the P.L.C. Law Firm. And today is April 8th, it's Friday, 2016, and I'm going to be speaking to you about what estate and trust beneficiaries or personal representatives and trustees who are involved in probate litigation in Florida need to know about the right to privacy in Florida. And it's rather appropriate. Not only do Florida probate litigation law firms see the issue of privacy come up all the time, from trying to object to a trust amendment or setting a trust document aside, but to will contests, cases of undue influence, cases of dementia and Alzheimer's, when you're either objecting to probate or you're trying to set a will or a codicil aside. And it's also appropriate because in the news we've noticed over the last few weeks some major invasion of privacy cases. The Erin Andrews case, which I believe took place in Georgia, was one where Erin's privacy was invaded in a hotel room, and a jury verdict awarded her tens of millions of dollars for damage she suffered based on that invasion of privacy. Closer to home in Florida, on the west coast of Florida, Hulk Hogan received a staggering verdict in excess of $100 million in his invasion of privacy lawsuit. He also received punitive damages in that Florida trial. So what does the right to privacy in Florida mean for people who are involved in Florida probate litigation and estate lawsuits throughout Florida? Well, first of all, why would this even be applicable? When we have an estate lawsuit or a trust lawsuit, the issue may come up where an individual, such as someone who is not an heir or somebody who is no longer a beneficiary, maybe they've been disinherited from a Florida estate plan or a will or a trust, seeks to try to be reinstated in that Florida estate plan. Maybe they file an objection to probate, they seek to set aside the will based on lack of capacity or undue influence, or they're seeking to object to a particular trust amendment that disinherited them. They may want to know how much money is in the trust. They may want to know what the person who created the will or the trust, the decedent or the grantor, did with their money during the last few years of their life. They want to know about the financial information of a particular person. They may also want to obtain medical records or neurological reports or psychiatric reports of a particular individual if, for example, a plaintiff has brought a will contest case in Florida or an undue influence case, arguing that somebody was forced to sign a will or a trust, or they didn't have the requisite mental capacity to sign a will or a trust at the time that an amendment or a codicil was signed disinheriting somebody. So the issue of one's private financial records and one's mental state, one's medical records and health care records may or may not be relevant. What do we need to know in the Florida estate and probate litigation context about the right to privacy? Well, first of all, you should know that the right to privacy is guaranteed for Florida residents in our state constitution. Article 1, Section 23 of the Florida Constitution expresses a policy that is necessary for courts to grapple with when someone seeks to obtain your personal financial information even after you're deceased, as well as your medical information. And so if you want to learn more about the right to financial privacy, maybe you represent the executor or personal representative of a Florida estate, maybe you're involved in a tortious interference with an inheritance lawsuit and you're defending the personal representative of an estate or the trustee of a trust, or maybe a family member who quite frankly inherited everything under mom or dad's revocable trust or their estate plan, and you want to object to the plaintiff or the petitioner trying to learn about financial information or medical information that maybe they're not supposed to know about. And maybe there was never any intent to share that information with this plaintiff or petitioner. What can you do? Well, let me give you a few cases that you can run to if you want to stop watching this video. Look at the Ryan case, R-Y-A-N. It's a 2013 case out of Florida's 2nd District Court of Appeal. It was issued on November 27, 2013. It's Ryan versus Land Source Holding Company, LLC. The Westlaw site is 2013 WL Westlaw 6212-025. And in that, the court grapples with the issue of the disclosure of personal financial information and how that may cause irreparable harm, right? So if someone is seeking to attempt to get information that you believe is confidential or privileged, you file an objection. If that objection is overruled, if a court orders that medical or financial information shall be disclosed, you can seek a writ of certiorari in your appellate court. And you can seek to have that information not disclosed, because once confidential or private information is disclosed, that's irreparable harm, right? The cat's out of the bag. So this is an appropriate issue for an appeal even prior to trial. So you can look at the Lien case, and that'll give you some background on the right to privacy from a financial standpoint. You can also look at the Russo case, R-O-U-S-S-O versus Hannon, H-A-N-N-O-M. That's a 2014 case out of Florida's 3rd District Court of Appeal. The site is 2014 Westlaw, W-L, 384-4037. That was decided on August 6th of 2014. And one of your first threshold inquiries that a Florida probate lawyer, a trial attorney needs to make is whether the information sought, whether it's medical records or financial statements, year-end statements, monthly statements, is relevant, right? And we know that discovery is limited to those matters relevant to the litigation as framed by the parties' pleadings. So you have to ask yourself, if somebody is arguing that a will or a trust is invalid based on lack of capacity or undue influence, does it matter whether that person, the decedent or the creator of the trust, the person who signed the trust amendment or the will or the codicil, does it matter that that person is a billionaire and worth billions of dollars, or whether that person is worth $1? Take a look at the pleadings, see how the allegations are framed by the pleadings, and so that's one of your threshold defenses. The examination for the trial court is, do the pleadings implicate the financial data of the person who's the subject matter of your Florida probate lawsuit? We all know that confidential communications are privileged, and the Florida Evidence Code has a number of exceptions or protections for communications that are not discoverable, that are privileged, such as clergy, attorney-client, and there are spousal and accountant privileges as well. And then finally, you could look at the Walther case, Walther v. Osinski and Cathcart, PA. That's an April 26, 2013 case out of the 5th District Court of Appeal in Florida, 2013 Westlaw 1775510. That also references the Barker case, B-A-R-K-E-R, about certain documents that have a protective status. Personal financial information is taken very seriously in Florida. It's clear that the Florida Constitution's right to privacy does cover your personal financial data. So if you need assistance with an appeal on that issue, take a look at the Russo case and take a look at the requirements for a writ of certiorari. We know it's an extraordinary type of relief, but there's principally 3 elements that you have to demonstrate for the writ to be issued. You can take a look at that, and that'll be helpful as well. Remember, the Florida appeals rules or appellate rules, or the guidelines for appealing a Florida probate court order, changed over our recent past, and you can now appeal a number of issues, probate issues in Florida, without waiting for the end of the Florida probate trial or the estate trial. So this gives litigants, and certainly Florida trust litigation lawyers and estate litigation lawyers, new ammunition to protect their clients and assist their clients with their legal matters, because now you're able to get a Florida District Court of Appeal to review certain trial orders that previously you couldn't. You had to wait till the end of the litigation. So the Florida right to privacy, why is that important to Florida estate and probate litigation law firms. That concludes my remarks today.